Hello everyone, Dr. Smith, physical therapist and law student here. As you can tell based on the format of this video, it's not my typical format, but what I'm going to do today is break down the most common defenses that you can use when it comes to employment contracts, travel contracts, and contracts in general. Before I get into that, please like this video, please subscribe to the channel, and make sure you turn on notifications to make sure you do not miss out on any new content. And as always, if you have any questions, comments, complaints, or concerns, please comment below in the comment section, and I will try to respond to you as soon as I possibly can. Many of you have reached out to me, whether it be on Instagram, YouTube, Facebook, email, asking if your contracts are fair and valid. Sometimes it's just a terrible employment contract with a crazy non-compete. Sometimes it's just a trash therapy contract that we need to redo to make sure that your recruiter is being fair and transparent with you. Now, unfortunately, many people sign these contracts and they don't know how to get out of them, if they're fair, if they're legal. That's why I'm making this video, and that's why it's formatted a bit differently, because I want to be as clear as possible and make sure that I'm not misspeaking, so you actually know what's going on and you can use this video as a reference. One thing that I want to make very clear before this video moves forward is that if you watch this video and feel that you have a valid claim and a valid out to your current contract, please contact an employment or healthcare attorney in your state to seek counsel and then move forward with their recommendation. Now, there are multiple defenses in contract law, such as intoxication, being a minor, but we're not going to cover that in this video because this video is going to cover the 3 or 4 most common defenses that you can actually utilize as a healthcare provider to get out of your contract and prove that your contract is not actually valid. The first defense I'm going to cover is unconscionability. Unconscionability may be asserted by a party who has entered into an unconscionable or unfair contract. Generally, a contract may be procedural and or substantively unconscionable. A contract is procedurally unconscionable when it results from a significant inequality of bargaining power between the two parties. Again, this is what we see with employers giving unfair contracts to employees, and this is a defense you can use if your contract is objectively unfair. Now, this is going to be much harder to prove as most employers actually are fair, but if you have a very one-sided contract, very easy defense that the courts will say, hey, it's not a valid contract, and you're out of it. Again, some examples of procedurally unconscionable contracts are standard form contracts in which the signing party does not have the power to negotiate or modify the terms, as well as contracts containing buried items that are actively hidden, something with small fine print, or something that is not easy to see on the side or just hidden somewhere, different font sizes, anything along those lines. And again, a contract is substantively unconscionable when its terms are overly harsh or one-sided against one of the parties. Now, this alone may resonate with you as a physical therapist or a healthcare provider because you may have signed an unfair contract. I'm hoping this video shows you that you actually have a defense to this contract by just claiming that's unconscionable. The next defense is misrepresentation. Misrepresentation may be asserted by a party whose assent was induced by a misrepresentation or an untrue assertion that was fraudulent or material, as long as the party's reliance on the assertion was justified. So first of all, a misrepresentation is an untrue assertion or a statement that is not in accordance with the facts. If somebody lies to you and you sign a contract, you have a misrepresentation claim. Again, if they don't disclose anything, you may also have a misrepresentation claim. Non-disclosure may also be a misrepresentation when the non-disclosing party knows that disclosure is necessary to correct the other party's mistake or has a relationship of trust and confidence with the other party that entitles the other party to disclosure, such as a fiduciary relationship. As an employer, you actually have a special relationship to your employees, and employees actually have a special relationship to their employer because of the fiduciary relationship. So anything that is not disclosed in the contract or should have been, you then have a misrepresentation claim. Next, the misrepresentation must be fraudulent or material. A misrepresentation is fraudulent when intended to induce the party's assent and made by someone who knows or believes that the assertion is untrue or who isn't confident that the assertion is true. So if they lie to you, but they don't know they're lying to you, but they're not really sure what's going on, you actually still have a misrepresentation claim. That's kind of tricky and it's kind of hard to prove, but if you can prove that somebody wasn't sure of something and they promised you something they weren't sure of, you have a misrepresentation claim. A misrepresentation is material when it is likely to induce a reasonable person's assent or when it is known to be likely to induce the party's assent. Again, you feel like you're being lied to, manipulated, you have a misrepresentation claim. Finally, the party's reliance on the fraudulent or material misrepresentation must be justified. This means that the misrepresentation must not be an opinion. Again, it has to be factual, and you have to prove that you know that there was misrepresentation. The easiest example in this case is, say that you have a travel recruiter who promises you something and then you get a pay package that's different than what they said, what they texted you. Then you actually can bring a misrepresentation claim against the recruiter because they lied to you and the contract isn't fair. And you actually can also take the contract and then recover the damages of what they promised you. Of course, in this situation, you want to have proof of what they promised you, a screenshot of a text, something along those lines besides just hearsay. So in those situations, if you can prove that the recruiter lied to you, you can actually get out of the contract based on misrepresentation. Additionally, if you take the contract, they then owe you the extra money promised if you bring this claim. Now, the third defense is illegality. This defense is easily asserted if the contract violates public policy. Also, as we saw with the first defense, it can kind of go in here. Something that violates public policy would be a contract that says you can't treat patients for 5 years on a 100-mile radius. Obviously, that violates public policy. You're denying people healthcare services. Again, why non-competes never really hold up in healthcare are because they violate public policy and the contract is ruled void or illegal if you assert illegality. Now, the last defense, and this is a rare defense, but I have seen it in therapy and healthcare, and that is undue influence. Undue influence is a defense to a contract in a situation that affects mutual assent. Undue influence is taking advantage of another person through a position of trust in the formation of a contract. This most commonly occurs when students go out to professors' clinics for jobs, whether it's therapy, healthcare in general. You have a relationship of trust to this person because they were your professor. They offer you an unfair contract or a bad contract because they know that you trust them, but then you can assert undue influence. Again, if you have a relationship with a CI, other things along those lines, you can then assert undue influence. So to recap, if you have an employment contract or a travel contract or just a contract in general that's unconscionable, that's misrepresented when you signed it, that's illegal, or you signed under undue influence, you actually have a defense to the contract and the courts will void that contract and not hold it up. And I wanted to make this video to help you guys out. I see lots of questions about this, so make sure you know this, you understand it, you research it, you seek counsel in your state. I hope this video made sense. I'm sorry I got short of breath there for a second, saying so many complex words so fast, but hopefully you made it through this video. If you have any questions, please comment below. Oh, and one more thing before I go, I actually am doing another $500 cash giveaway for any student or new grad who has graduated during the pandemic or buys my course through May. I'm giving another $500 in cash away. As you know, I'm the founder of the Only 10 CEU course that gives away cash. All right, guys, I'll see you in the next video. Thank you.